All rise. The United States Navy Marine Corps Court of Criminal Appeals is now open into session. God save the United States and this honorable court.
Thank you. Please be seated. We're here in an oral argument in the case of United States versus Private First Class Cody Saxman. Preliminarily, the government made a motion to submit supplemental matters yesterday, and it was granted by this court. Additionally, before we begin, I would like to ask the appellant what is his position as to AOE number 2?
Yes, Your Honor. AOE 2 is no longer an issue in this case.
Very well. Are you ready to proceed?
Yes, Your Honor.
Please proceed.
May it please the court. My name is Captain Jeff Liebenguth, and I represent the appellant in this case, the Private First Class Cody Saxman. Senior Judge Mitchell, with your permission, I'd like to reserve 5 minutes of my time for rebuttal.
Very well.
The appellant was charged within one specification of knowingly possessing 22 video files of child pornography. But the members found him guilty by exception and substitution of possessing only 4 of those files and not guilty of the remaining 18. However, the members did not indicate which 4 files they found the appellant guilty of and which 18 files they found him not guilty of. In order for this court to conduct its Article 66 factual sufficiency review, it must be able to take the exact same 18 not guilty files and set them to the side and not look at them.
Let's assume, counsel, for the moment that I agree with you that the status quo is unpalatable. Can't we send this back, reconvene the members, and ask them a very simple question?
No, Your Honor.
Why not? O'Neill issued just last Friday, the Court of Appeals for the Armed Forces quite properly reaffirmed longstanding military law that the trial judge has inherent powers, and clearly among them would be to reconvene here, wouldn't it?
No, Your Honor. Augsburger clearly states that any hearing and revision is precluded.
But Augsburger isn't that particularly talking about a hearing and revision where we're going to get into the substance of the matter. For instance, I would agree with you. If we reconvene the members, we sent them into a room, we gave them the evidence again, and said, hey, here are the pictures, here are the videos, here's whatever the name files, whatever we were going to put in front of them, and we say, please pick. Clearly, you have a violation there. But what if you just brought the members back, put them in the jury room, didn't even put them in the jury room, just sat them out in open court and said, gentlemen, there's a lack of clarity with regard to your findings. We'd simply like to ask you. Give them a findings worksheet, supplemental to the one that's already there, and have them check off as to each of the 22. Couldn't that in theory be done?
No, Your Honor. Augsburger also states that the military judge, in a case like this, had 2 opportunities to clarify. And that was, one, when he gave the findings worksheet to the members, and then second, when he got the findings worksheet back and still saw that there was an ambiguity, he should have corrected it at that point. And then, again, this can't be sent back. Our position is under Augsburger to do exactly as you say, Your Honor. Because this court must be able to take the exact same 4 files which form the basis of appellant's conviction and review only those. Because the findings do not disclose that information, this court cannot conduct its Article 66 factual sufficiency review.
Captain Liebenguth.
Yes, sir.
Now, the specification at issue here, this alleges a Clause 3, Article 134 offense, correct?
Yes, sir.
Okay. You agree that it does allege a Clause 3, Article 134 offense?
Yes, Your Honor.
Okay. And that would be specifically under 18 U.S.C. 2252A, paragraph A5A?
Yes, Your Honor.
Okay. Now, doesn't that provision of the statute specifically prohibit possession of some sort of material, such as a book, a magazine, periodical, film, videotape, or computer disc that contains an image of child pornography?
Yes, Your Honor.
Is that how it's expressly pled in the specification?
No, Your Honor. The statute is really not relevant in this regard because the crux of the issue here is that there was a finding of not guilty at trial. What the government's asking this court to do is first ignore.
Well, I understand what you're asking. I mean, it's a well-written brief and all that, but I can't agree with the statement that the statute is not relevant. I mean, in order to find the appellant guilty of this specification, it has to allege an offense under that provision of the United States Code, right?
Yes, Your Honor.
So now, that provision of the United States Code makes it criminal conduct to possess material, right, that contains an image of child pornography. Is that correct?
Yes, Your Honor.
Now, the specification at issue here alleges possession of 22 video files. Are 22 video files material?
Yes, Your Honor, I believe they are.
Do you hold up those files?
I cannot, Your Honor.
You can hold up a disk that contains those files, right?
Yes, Your Honor.
Okay. So does this specification fairly imply, if it does not expressly allege possession of a disk, does it fairly imply possession of a disk that contains an image of child pornography?
Yes, Your Honor. But the crux of the issue here, as was in Walters, was the finding of not guilty, Your Honor. And really, again, the government, we're going to come back, I think, again and again to the fact that the government asked this court to ignore the way that this was charged. He wasn't charged with possession of child porn. He was charged with possession of 22 video files of child pornography. And that was
Well, you just said, by fair implication, he was charged with possession of a computer disk that contains an image of child pornography. No?
I don't know that I don't agree that by implication that I agree to that, Your Honor. I think, again, this court is left with how this was charged.
Counsel, is there any evidence in the record that illustrates that the trial judge in this case, in fact, gave great weight to the number 22?
Yes, Your Honor.
What would that be?
He specifically instructed the members that they had to look at each and every one of those files and vote on them individually.
That's 794 in the record, correct? And he goes forward and he tells them, in fact, what we can't have. He says what you can't have is one member believing one video meets the definition and then the other 9 believing 9 different meet the definition, because if there were only one video charged, you would have to have a 2/3 concurrence for that one particular video. And he treats every video differently. What significance do you see in that?
Well, the significance, Your Honor, is that it set up the opportunity for a finding of not guilty on each of the 22 video files. And indeed, that's what happened. The members voted, and on 18 of those files, they found that they did not have 2/3 vote to convict. They did have 2/3 on the other 4.
Now, Captain Liebenguth, if you possess a computer disk with more than one image, is that more than one offense under 2252A5A?
The law is unsettled in that regard, Your Honor. Both of the cases cited by the government, Police and Plain, assert that if there were separate transactions, that potentially you could be charged with separate specifications. And indeed, the record reflects that some of these files were created on different days. So potentially they could have been charged as separate incidences. Again, what this court is left with, though, is how it was charged. And again, the government is asking this court to ignore the way it was charged. And then also ignore the specific findings of the members. They're asking you to ignore the finding of not guilty. And words have meaning. Not guilty is clear and unambiguous. What is ambiguous is the fact that this court does not know which of the 18 files the appellant was acquitted of. And under the principle flowing from United States v. Walters, this court cannot conduct its factual sufficiency review.
Riddle me this, counsel. What if this court were to have NCIS come over and give us a look-see at the items in question? We did so, and we found in our minds, in our judgment, all 22 to constitute pornography as it is defined and qualified under the statute. Where's our problem?
Your problem is, Your Honor, that Walter specifically said that you cannot review acquittals, and that's what this court would be doing. It would be reviewing acquittals, and simply cannot do that. All of the cases, Brown, Rodriguez, and Jones, that the government cites, there's a dispositive distinction between those cases, this case, and the Walters case, type cases. And that is that there was a finding of not guilty at the trial level. And that the findings were ambiguous, and therefore this court could not do a factual sufficiency review. When there's a Walters-type violation, the only remedy is for this court to set aside the findings and sentence and dismiss the charge and specification thereunder with prejudice. And that's what this court must do in this case.
What about under RCM 1102, where it talks about post-trial sessions may be conducted in revision, or 39A sessions, and it says the purpose is to direct or to correct an apparent error, omission, or improper or inconsistent action by the court-martial. Wouldn't that be a more appropriate remedy in this case to go back to the members? I want to go back to what Judge Maxson said, to go back to the members and have them clarify and specify which four images they found the appellant guilty of.
Augsburger clearly says, Your Honor, that that's not permissible. And again, the members would be getting into, they'd have to review all the files again, which 18 of them they acquitted. They would fall in the same problem. But more significantly is the fact that Augsburger says that's not permissible in this type of case. If there are no further questions, that concludes the appellant's argument.
No.
May it please the court. There was no not guilty finding here, and the government pleaded and the members convicted the accused of a single substantive offense.
Mr. Burkhardt, go ahead.
I'm sorry. Lieutenant Burkhardt, right?
Yes, Your Honor.
When there is a finding of guilty by exceptions, doesn't that necessarily entail that there is a finding of not guilty to some factual matter set forth in that specification?
Precisely right, Your Honor. A factual matter, but
Right.
was it an offense? And the answer would be no.
Okay, so in doing our factual review of the specification, if he's not guilty of certain facts in that specification but they're not identified to us, where do we start?
Well, Your Honor, let's go back to Walters. The review problem in Walters only exists if you have the presence of guilty and not guilty findings to offenses, not facts, Your Honor. And this is made most clear in Rodriguez at footnote 3. In Judge Ryan's opinion, she says exactly that. The Walters problem persists when there's a not guilty finding to an offense. So as here, the number 22 was not alleging 22 separate offenses. And as the supplemental cite from the government indicates, the government could not have charged 22 separate specifications on these facts because there was only one media. So when the members said those words in the announcement, when it was not guilty of the accepted language, it was simply not guilty to a greater volume of contraband, an aggravating fact that did not equate to an offense.
So alleging 22 video files was not necessary for the statute to allege an offense in this case, is that correct?
Absolutely, Your Honor. The statute only required proof of a single video file, a single video.
Well, I take exception to that. I think actually the statute requires that the accused possess some sort of material.
Absolutely right, Your Honor. And this
Now, is a video file material?
No, Your Honor. The hard drive would be the material, and as you pointed out in the appellant's argument, the statute says book. It describes media, magazine, in this case.
Something that can contain an image, right?
Yes, Your Honor.
Not the image itself.
Yes, Your Honor. So in this case, the government pleaded one single specification of possessing child pornography, and they listed 22 video files, but they were charging by necessary implication, and as we know from RCM 307C3, it allows pleadings by necessary implication. The government charged a single hard drive.
So there's no failure to state an offense in this particular case, then?
Correct, Your Honor.
Okay.
The issue turns on whether those 22 video files were facts that provided alternate ways for the government to prove all of the elements of the offense, or whether they were separate offenses, and they were not separate offenses.
But counsel, it doesn't appear that the trial judge or the government below believed that. The trial judge on page 794 of the record goes to extreme lengths to articulate the import of the members finding a verdict as to each and every vision put before them. You know, he talks about each video. If there's 22 video quantities, if some members believe that 5 of them meet the definition, if some of the members believe 20 meet the definition, you must vote on what? On the elements of those 5. If there's an agreement between all the members, there has to be an agreement, 2/3 majority, that believe that this particular video stop. For whatever reason, he stopped his paragraph. This goes on for 6 or 7 paragraphs, again and again reiterating the importance of the 22 separate videos. Moreover, isn't this an instance where the United States has since simply foisted itself upon its own petard? How many years has this court articulated the problem with counsel below overcharging, not charging properly, inarticulately charging? Isn't that what the government finds itself fenced in by here? The United States theory of the case was that there were 22 videos, and they put it in the same specification. This court didn't compel that to do that. You certainly, counselor, you're way wiser than that to compel them to do that. They did it to themselves. Why should we somehow let them out of the fox trap that they put themselves in?
Well, Your Honor is correct. The military judge did instruct as if the number 22 created separate offenses, but this court is not bound by that. This court, and the review problem that the court is addressing, is whether the actual elements of the offense were satisfied. And the elements...
But, Counselor, was that not the theory of the government at trial? When you read the closing argument of counsel for the government, trial counsel below, it's clearly, and the defense below in their argument, they rejoinder the 22 videos. That's what this case was about. Aren't you really asking us, in a case where we may not even have the ability to step out onto the precipice of 66 review, aren't you asking us to retry the case?
Absolutely not, Your Honor. The general verdicts theory applies in this case. And as counsel has pointed out, the facts of Brown and Rodriguez, and before that Vidal, are different than this case. But the theory of general verdicts still applies.
Captain Berto, I think that's correct. It's clear that you understand what was reasonably implied by the specification here, but the military judge, did he not instruct the members on the law, and incorrectly so?
Absolutely, Your Honor. And that's...
If he incorrectly explained the law to the members, and they convicted the accused of an offense with their mistaken belief of the law, is that a proper conviction?
It is a proper conviction, Your Honor, because had the military judge instructed properly, he would have instructed, as was done in Brown, you can find any one of these images, and you need not even agree on which image, just as this court need not agree on review. So when this court exercises its review function, it's reviewing what were the actual elements, not as the military judge incorrectly instructed. What are the elements under 2252A? And were those satisfied beyond reasonable doubt? Those elements only required a single visual depiction. So this court can review, and if it finds a single visual depiction satisfied all the elements, the accused is convicted because he was charged as pleaded with a single substantive offense.
But counsel, doesn't that require us, even going down your road here, doesn't that require us to deploy the judicial Ouija board and somehow determine to evaluate these videos that have been independently evaluated by a jury? The members have spoken. They didn't just go out of they went way out of their way. They cross out the 22, taking Judge Ware's advice and listening to his instructions, and insert a 4. They convicted the appellant by exceptions and substitutions. This wasn't the taking of a general verdict and then the delivery of same. They clearly contemplated this in their findings.
Sir, RCM 918A1 defines a general finding to include exceptions with or without substitutions. This was indeed a general finding. The general verdict theory still applies. In Rodriguez, Judge Erdman's dissent points out that a Walters issue is in fact a general verdict.
Alas, the dissent. I mean, the problem we have here is, let's say Walters was never decided. If I'm walking in the country you're asking me to, I have to say that we can do a 66 review based on the elements of the offense Judge Ware advised the members of, pretending for a moment that he didn't tell them about individual findings as to 22 individual videos. Am I correct?
Absolutely, Your Honor. That is precisely the theory of general verdicts, and that's what the military judge should have done in this case. And the fact that the military judge incorrectly instructed, that would be reviewed, tested for prejudice, possibly harmlessness beyond reasonable doubt. But in this case, it benefited the accused. It held the government to a higher burden. It required them to prove each element for each image. So it clearly didn't harm the accused in any way.
Isn't that because, Counselor, that's how the United States had deigned to charge this Marine?
Your Honor, there would have been no difference in this court's review function if the government had included the number 22 or omitted it from the specification. Because
by including the 22 video files in the specification, hasn't the government inserted additional facts into the specification the government has to prove beyond reasonable doubt?
No, Your Honor, because the government doesn't have to prove every fact in the specification. The government only has to prove the elements of the offense.
But didn't the military judge specifically advise the members that as an element of the offense, that the accused only possessed 22 video files of child pornography?
Well, it was somewhat ambiguous because he first said that, Your Honor. In describing the first element, he said 22, and then the third element, knowledge, he says unimaged.
And again, and that's and the accused knew the material that he possessed contained an image of child pornography. So I think that goes back to the fair implication that, it implies possession of a physical material, like the computer disk in this particular case.
Yes, sir.
But also, as an element, not only do we have material, the computer disk itself, but you've got an additional fact in here, and that is 22 video files of child pornography. Do you know?
Yes, Your Honor. But 918C, the discussion section, says it is not necessary that each particular fact advanced by the prosecution, which is not an element.
But this is an element.
Absolutely not, Your Honor. The elements come from the statute.
The military judge told the members that this was an element of the offense.
Yes, Your Honor, but in Medina, this court said that the military judge can't rewrite the statute. If the statute says something, the judge erred in not following what the statute says. In this case, the statute only required unimaged. So the fact that the military judge gave an additional element of 22 to the members doesn't change what Congress put in the statute.
But, Counselor, that's not what the jury did here. The members had something very different in mind. It's obvious from their evaluation of the case. The findings worksheet speaks for itself. The questions they come back and ask Judge Ware speak for themselves. Judge Ware's instructions in rejoinder to those questions from the President of the Court instructs this court. I mean, these are all things in the record that are obvious to us. Let's pretend for a moment that in your usual wisdom, you have convinced me. And I'm ready to set aside my previous reading of Walters and its progeny. How do we do a 66 review? We still have to treat the member's verdict the way it was delivered to us. I mean, you're essentially saying, okay, you can find Judge Ware's conduct in this case to be totally erroneous, and do we return the case? Do we have the case somehow retried? How do we fix this?
Your Honor, the theory of general verdicts applies if the Walters problem does not exist. Here we have no Walters problem because we do not have an acquittal of an offense.
Lieutenant Burke, maybe I'm not being clear, and that wouldn't be the first time. If this court under 66 has to review all the evidence upon which the appellant stands convicted, but we can't discern what evidence it is upon which he stood convicted by a 2/3 majority inside that jury room. Why? Because neither they nor in answer to a supplemental findings question from Judge Ware answered that question for us. How do we commence a 66 review? What evidence do we look at?
Your Honor, I invite this court's attention to Brown's CAF case, in which they explain the theory of general verdicts, and they say that this court, in exercising its 66 review, doesn't need to know which theory, which fact, or how many facts the members found a conviction of, because we have a general finding.
Except except if this court views those 18 findings told to the members by Judge Ware that they had to reach a determination on to be acquittals, because per our almost endless de novo ability founded by the Court of Appeals for the Armed Forces and by statute and explained in U.S. v. Smith, we cannot review an acquittal.
Precisely, Your Honor. Did we have an acquittal here? And the answer is no. The government pleaded a single substantive offense, and by altering that number, the members didn't acquit him of images. The members...
They found not guilty of possession of 22 images.
Yes,
or 22 video files.
Which altered the volume of contraband, Your Honor. It's the same thing as if...
But counsel, that's how the verdict form reads. You're saying there are no acquittals here. The verdict form, you already asked me not to listen to Judge Ware, and you're asking me not to listen to what the members now. The members came back on the findings worksheet and they said, of the accepted language, not guilty. Under any judicial interpretation in Anglo-American jurisprudence, that's called an acquittal.
Your Honor, consider if they changed the value in a larceny specification. Is he being acquitted of an offense? No, they changed the volume, the amount. And consider this hypothetical, Your Honor. The accused is charged with possession of 22 grams of cocaine. The members accept out the number 22 and replace the number 4. Does this court have a problem in reviewing and not knowing which grams the members acquitted him of? No, because they didn't acquit him of anything.
But here, Counselor, wouldn't you agree we have a qualitative problem? We have a unique problem to child pornography. We have the need to evaluate each and every... If I were back on the trial bench sitting alone, I'd still have to look at each and every video to determine whether or not that video crossed the line of 2252. If it doesn't cross the line, then I can't convict the accused for that particular video.
Absolutely, Your Honor. So let's change the hypothetical a little bit. He's charged with 22 individually labeled bags of marijuana. Evidence is presented at trial. Some of those bags were oregano, or the accused believes some of them were oregano. If he reduces the number 22 to 4, if the members do that, could this court review? Absolutely. You don't need to know which bags resulted in the conviction of the single charge, possession of contraband. Here we have possession of contraband, and by changing the volume of contraband, the members didn't acquit him of anything.
So the United States is arguing that the government's decision, I'm sure made prudently below, to charge, to implant into the charge 22 images or videos, not 14, not 87, but 22, garnered no importance upon itself.
Your Honor, clearly it would have been more artful to omit the number altogether. And in that case, the judge wouldn't have given this erroneous instruction and we wouldn't be here. But by including that number, it doesn't change the number of offenses. The number of offenses has, to this date, only been altered in a specification by the use of on diverse occasions language, which would signify that the government is charging multiple discrete offenses within the specification. Without that language, the government is signifying that it is charging only a single offense. So the inclusion of the number 22 doesn't alter that fact. It doesn't alter that. It's the same as if the government had pleaded the accused was wearing a red shirt, or he was wearing a shirt that said, "I like child pornography." It's a superfluous fact, in this case aggravating, more likely to increase the accused's punishment within the maximum range. But it's not an element, it's not an offense, and it need not be proven by the government.
Let me ask you a hypothetical. And let's just say that of the 22 images, half of them were, let's say, adult, and half of them were child pornography. You with me so far?
Yes, sir.
All right. And let's just say that the adult pornography was particularly disgusting, and the jury found him guilty of those, the adult, without a determination as to which files they found were child pornography. How can we do a review and make sure that what he was convicted of is in fact what he did?
Your Honor, that's exactly the United States versus Rodriguez CAP case, when they said this court can review under its Article 66 powers whenever there's a finding of guilty, a general finding of guilty. The court would then accept out whatever images it believes didn't satisfy the elements. If some of the images were adults, the accused, in fact, the court wouldn't accept anything out. The court, in this case, could accept out the number 22 and say we find him guilty of possession of child pornography, period. But the court wouldn't need to specify which images.
So you're saying we can disagree with the members? They can find him not guilty of certain conduct, and we can find him guilty of it?
Your Honor, you could omit the number.
Well, by omitting the number, I mean we're opening the door for us to disagree, to impose our judgment over that of the original fact finder, right?
Your Honor,
as to a not guilty finding.
Your Honor, this court's charged with reviewing the elements, whether the elements were satisfied. So we look to what are the elements?
The elements as articulated by the trial judge.
No, Your Honor. The elements as articulated by Congress. The fact that the military judge gave this erroneous instruction, and I recognize Your Honor has hung up on that, but I would invite this court to revisit its opinion in Medina, in which he said that the judge can't change the statute. The judge can't read a different affirmative defense, or the burden shifting in the affirmative defense, other than what Congress said.
So we're to ignore the primary mandate given to the members when they substantively considered the culpability of the accused.
Yes, Your Honor. This court is charged with reviewing the elements and deciding whether they are satisfied beyond a reasonable doubt. And the fact that the military judge gave an incorrect instruction on the elements is something that should be tested for prejudice. It does not affect this court's review function under a potential Walters problem.
Let's say for a moment we go down the road you're having us go, to our own peril, and we decide that we're going to in fact test it for prejudice, and we find that prejudice exists. What's the remedy?
Well, at that point, Your Honor, we would invite the court to adopt what Judge Maxim has already articulated, sending it back for a rehearing. The RCM 1102 was changed to envision this scenario the government would submit, because the military judge still has the power under RCM 1102 to send it back and have a rehearing and ask only a single question. Do you recall which images you were convicted of? You are not allowed to reconsider. You are not allowed to redeliberate.
Alas, what if the answer is no? Where are we?
Then the court would be required to dismiss with prejudice under Walters. But Walters, Your Honor, only applies in the presence of guilty and not guilty findings. Here we have a not guilty to superfluous information, to an additional fact, a volume of contraband. And because it wasn't an acquittal to an offense, we don't have the presence of guilty and not guilty findings, because that didn't equate to offenses. For those reasons, this court should affirm these findings and sentence as approved below, unless there are further questions. That concludes the government's presentation.
Thank you. Nelson.
In rebuttal, the appellant just offered that the government confuses RCM 918A1. It was not a general finding, and that is the crux of the issue here. When we're talking about Walter's issue, a general finding, what we're talking about...
Why not, counsel? It doesn't say on diverse occasion within the specification. How can we walk into Walter's country if we're not there? We haven't crossed the border yet. I mean, aren't we constrained? Wouldn't that be an activist move by this court to interpret this as a Walters case? I've read Mr. Bergdorf's interpretation of the law in his fine brief. He's usually right. How is he wrong now?
Yes, Your Honor. In this case, he's wrong. The on diverse occasions language is only significant because it sets up the opportunity for a mixed finding that is ambiguous. A mixed finding of guilty and not guilty that's ambiguous. That's exactly what we have here. That's the principle of law that flows from Walters. And there's no difference between appellant's case and Walters on that issue.
Except in Walters it says on diverse occasions.
That's right, Your Honor. And that's one situation.
And not here.
That's right, Your Honor. But the
so you want us to make law?
No, Your Honor. The Army Court of Criminal Appeals encouragement has already faced a matter similar to this. And they found in applying Walters, in that case there was no on diverse occasion language. There was multiple misconduct charged within one specification. And the findings did not disclose.
But that was a duplicitous specification, wasn't it? It alleged more misconduct. I mean, several forms of misconduct in one specification. In this particular specification, it alleges one act of misconduct, and that is possession of material that contains an image of child pornography.
That's not what it alleges, Your Honor. I disagree respectfully. It
alleges that, and it alleges more. It alleges not only was there an image, but that it contained 22 electronic files on that media. I mean, you've already told me that it reasonably implied that there was a computer disk alleged in the specification, right?
Yes, Your Honor.
Okay. So we've got that. And we've got it alleges that it contains an image of child pornography, right?
Yes, Your Honor.
Okay. And in addition to that, we've got stuff that's not really a part of the statute, but the government has chosen to plead this as a fact that they had to prove beyond a reasonable doubt. Now, the members didn't find all those 22 electronic files to constitute child pornography, but I mean, there's still an offense there that they convicted him of, right? We wouldn't find him by reviewing all that information. We're not upsetting their verdict, are we?
Absolutely, Your Honor. They clearly found him not guilty of 18, and that is the crux of Walters. What the government's asking this court to do is that the members, or excuse me, the court has already.
Counsel, what I'm challenging you to do is because, as you well know, that's why we do this, so that we can get your bright minds to tell us, to spur our thoughts into other things that we've tried to consider. Let's say for a moment we believe that Walters doesn't apply.
Yes, Your Honor.
Technically.
Yes, Your Honor.
We don't want to cross that line. How do you win?
Quite easily, Your Honor.
Let's say we treat it as a general verdict.
Yes, Your Honor.
And it's apparent to me, if we treat it as a general verdict, that the members certainly convicted him of something.
Yes, Your Honor.
Okay? And were pretty ardent about it. In fact, they convicted him of what they determined to be 4 videos that crossed the line.
Yes, Your Honor.
What's the way forward?
Well, that was the issue in Walters, Your Honor. The court knew that they convicted him of something.
Counsel, I understand.
But assuming that it doesn't apply, we don't have to call this a Walters issue, Your Honor. We can call this a hybrid Walters issue or something else. The principle of law, which flows from Walters, is what applies. And in that regard, there's no difference between these two cases. If we want to call this the Saxon rule, that's fine.
Let's say we do consider it to be different. Let's say Mr. Bergdorf is accurate with regard to his vision of the law. Let's say for us to cross over the Walters line in this case at this moment would be premature. What's our immediate remedy? What would our immediate options be?
I'm sorry, can you restate the question?
Sure. Wouldn't it be proper if we treated this as an instructional error, and an instructional error upon which we have found prejudice, because the members clearly would have relied upon a substantive instruction and a misnomer of an element by way of instruction? Let's say we reach that conclusion rather than dealing with it as a Walters case. How do we proceed by way of remedy?
Well, the appellant's position is that you can't, Your Honor. That we're stuck with the record as it is. The government cites
Could we send it back for a hearing and revision to ask the members to explain their verdict if we treat it as a case, and Senior Judge, if that's okay if you can answer the question, because he's out of time. If we treated the case as an instructional error case?
Your Honor, if you did that, you're still going to be asking the members to review acquittals. And that is, they're going to go into and look at 18 video files to determine of those 22. And that's simply prohibited under double jeopardy principles as articulated in Walters and other cases that came after.
Do you have anything? Can I have one more question, please? Can we say we disagree with you and we find that we can send it back for a post-trial session with the members assembled so that they can clarify, explain what they intended by their findings. But for whatever reasons, as time's gone by, maybe some of the members weren't available or what have you, they were unable to answer the question. We don't remember which 4. Where are we then?
Well, you're in the same position. You're looking at mixed findings which are ambiguous. Under this court's Article 66 powers, it cannot review ambiguous findings via the principle outlined in United States v. Walters.
Matter submitted. Thank you.
All rise.